Hello again. This is part two of the Core Interpreter Ethics and Skill Building workshop. We're going to talk a little bit further today. We're going to go into module two in the introduction of the law, the core system, and the core procedures. In your book, in your page 20 of your manual, you're going to find more information about these are concepts that you will be probably asked to answer multiple choice questions in your written exam. So I don't want to slow down a lot here. This is just theory and things that you can read on the manual and learn about. But definitely, basically, what is crime is when somebody breaks a norm or a regulation that has been previously established, and those regulations and norms have been grouped within criminal law. The criminal law prescribes um, depending on what type of conduct or violation or disorder occurred, the law determines what the punishment will be. And this is one thing that sometimes people are confused about because they think that the judges make up their mind for each particular case. The law is already written and the punishment is already written. All of that is in Tennessee, for example, in the annotated code, the Tennessee Annotated Code, and that has all the laws and all the mainly the variations, and the judges obviously adapt that. But technically, the judge already has a base or a guideline to go by, so it's not like they just make up their mind as they go. There are two types of crimes. One is misdemeanors and the other one is felonies. Misdemeanors are what we call minor crimes because there is no word in Spanish, for example, so probably there is no word in other languages as well because unless we have a similar judicial system, we're not going to be able to see that. That particular word. When we interpret misdemeanors, we call it minor crimes. And when we talk about felonies, we talk about serious crimes. So the one thing to note is that often people who, even though they don't speak English, but they have been in jail for some period of time, they actually start learning the words. So you will hear Spanish people talk about felonías. Felonia is not a word. It doesn't exist in the Spanish language. But sometimes if you say a, un delito grave or un delito mayor, um, they don't even know what it is because they're used to calling them felonia because they learned the meaning of felony or felonia at the jail. So sometimes keep that in mind. Sometimes my habit is to often say, when I know that there are those types of issues, I will say the proper word, especially on the record. When you're in court, in open court, you always say the right word. But if I'm talking with an inmate and their attorney, for example, and they're just having a conversation, I will typically say a a serious crime or a major crime, or as they call it in jail, a felonía. You know what I mean? Like I will say un delito mayor, un delito grave, o como le dicen en la cárcel, felonía. They'll make sure that, I mean, keep in mind that that is not a word because if you could put that in your exams, you're not going to get it right. So misdemeanors are punishable with up to 1 year in jail or an alternative sentence. That means a probationary period, meaning, and different courts call it different things. In Tennessee, we call it probation. Most of the time they will say probation or probationary period. The problem is that there are different programs for probation. For example, we have in Davidson County, there is state probation, there is the sort of local, or the courts may have a probation, general sessions probation, for example, is a different one, and they do call it the same, but they will differentiate between state probation and general sessions probation or the local probation or whatever. But then they also have a program called community corrections, which is sort of an intensive probation. So they're all probation. So we all call them, conditional freedom or, provisional freedom or something like that. And I don't want to keep saying it in Spanish because I know many of you speak a different language. But you will find and will identify what that term or that language is, what that specific term that you will use. But just keep in mind that, just find out, like sometimes when you're talking to people and they mention those terms, just ask what it is if you don't know. So anytime they say alternative sentence, or some places will say a an alternative, a 1 year on the shelf, and what that means is that the sentence is actually technically hanging on the person's head. Is they will be if during a period of 1 year they don't get in trouble again, everything is okay, and the charge may not disappear from their records, but it won't affect them. In other words, it ends up showing as resolved in one way or another, and there are many ways to do that, so I can't go into that because it's too big a subject. But if they were to get in trouble before that time, or they don't obey by the probation rules, they could potentially, the judge could potentially put the sentence into effect, which means make him pay that time in jail. This is important also when it comes to immigration as well, because people tend to get out of the country or are deported, and then they re-enter illegally. And when they re-enter, there's already a warrant for their arrest because they violated the terms of probation, because they were unable to report to probation. So basically, misdemeanors are minor crimes, things that are punishable with up to 1 year in jail or alternative sentence. They are classified as class A, B, or C, A being the most serious. That is pretty much all you have to know for the test, or they might give you an example of, a crime and what was the sentence, and then they'll tell you, is this a misdemeanor or a felony? Felonies are all punishable with 1 year or more in the state prison. That doesn't mean that they all are going to go to the state prison. Some parts of the state prisons are paid here at the local jails as well. They are also classified as A, B, C, D, or E, A being the most serious. You can read more about this in page 22 or 23, about 23, 22, 23 of your manual. Important to know, exam question. First-degree murder and felony murder are the most serious crimes, and neither one is classified as A felonies. They are simply first-degree murder and felony murder. They're not a felony A, B, C, or D. They are just this most serious charges because they are punishable by life imprisonment with or without parole, or by death. The felony murder is a concept that you might want to learn. It means that a murder occurred during the commission of a serious felony. For example, if you have an armed robbery and you're just the driver, and you are one of three people, two people go inside the car and you're just waiting outside. You know that they're going in there to rob the bank. You don't know that they're going to kill anybody, but you know that they're going to go rob the bank. So the fact that you know that makes you a part of that crime. And let's say that these two people walk inside the bank, and for one reason or another, things go south and they kill one person or two or three, whatever. Now, all of three of you are responsible for that death. So the first-degree murder has specific characteristics and stuff, but one of them mean the intentionality of the person. So it could be that the person who pulled the trigger is charged with first-degree murder because obviously he had the intention of going and attempting to rob a bank with a weapon, which means he was ready to shoot somebody. But felony murder means that a murder occurred during the commission of a serious crime, which was the armed robbery in this case, which it was a felony, right? No, you don't know, right? But an armed robbery would be a felony. So during the commission of that armed robbery, somebody died. Now you may be charged with felony murder. So what is a statute of limitation? Exam question, by the way. It is the time that the prosecution can actually go after a person for a particular crime. The clock always starts ticking on the statute of limitation when the crime occurs. The most misdemeanors, the little crimes, the ones punishable for 1 year, for up to 1 year, most of them have a 1 year statute of limitation. Felonies have longer statute of limitations, and though they vary depending on what type of felony it is. Crimes punishable by death or life in prison have no statute of limitation. That's why you see many serial killers, serial rapists, people that have been found, any murder, and really murder has been found. I mean, there's cold cases, and there are detectives going after cases that people have been killed 20, 30, 40 years ago, and they eventually find the person that did it, and they will prosecute that person. So there is no statute of limitation for those two types of crimes. The other ones all vary, and for misdemeanors is generally a year, and it starts at the moment that the crime, the clock starts ticking when the crime occurs. Remember those. Those are, I remember. So the Tennessee judicial system, as you know, the judicial system is one of the three branches of government. You have the executive, the legislative, and the judicial system. The offices of there is an office of the attorney general, a district attorney general, and the district public defenders. Those are associated with the judicial branch, but they are not part of the court system. They're not part of the judicial branch of they work within it. They're like collaborative parts of it, but they're not specific part of the court system. The reason for that is because both of those are opposing. One is accusing someone, the other one is defending that someone. The judicial system, what is it represented by normally? What you see it in everywhere, like what is the representation of the judicial system? The scales of justice. So the scales of justice, what that means is that the judicial system is impartial. It is in the middle, and is there to make sure that the laws are followed, that the rules are followed, that the rule of evidence and any kind of procedure that is supposed to happen in the court are taking place in the proper way. But they are not in one side or the other. Therefore, the other parties are not part of the judicial system. They're associated with it. The attorney general represents the state in civil litigation and in criminal cases in the appellate courts, for example. There are 31 district attorneys. The state is divided in 31 districts. These are probably going to be written exam questions. So keep an eye, look at them in the book in more detail. There are 31 district attorneys. They serve as prosecuting counsel, as the prosecuting attorney, a lawyer in criminal cases in the trial courts. And the public defenders and the district attorney is one person. They are an elected position, and then they have assistant district attorneys, which are the ones that we work with every day one-on-one in the courtroom. But we don't normally work with the actual district attorney. We work with assistant district attorneys, which are the district attorney's team, let's say. The public defender is the same. The public defender is one person that is an elected official, and then they have a team of public defenders that work with them. They work as a one body, and there are many of them, and those are the ones that we see all the time in court, and we call them the public defender, but they are actually assistant public defenders. There are also court-appointed private attorneys, and that is because there are circumstances where the public defender may have a conflict of interest and they cannot represent the person. So the court has the power to assign a free attorney, a private attorney, and if somebody that you would hire, and pay money to, instead of you paying them money, the court will assign them, and the AOC is who pays them. and they represent what is called indigent defense. That's why when we go to work, if we know that if they call us for something out of court, if they are the public defender offices calling us, we know that we're going to get paid by the AOC. If it's a private attorney, you want to ask if the person is indigent or if the attorney was appointed or was retained, meaning the person paid the attorney. Because if they are retained and they are not indigent, then the attorney will you have to make arrangements to get paid because the AOC won't. These are the 31 districts of Tennessee. This is a good resource to have because when you are invoicing AOC in the future, you will be able to refer to this, because every time you do an invoice, they'll ask you, if you go to different places at least, you will have to enter what district it is, and this is a place where you can look for them. This is just another view of that, and you can find it. There is the link as well, but it's just a little more graphic view. Types of court in Tennessee, courts. This is another one that may be a written exam question, so make sure that you go to the book and read this in detail. Remember, this PowerPoint is just a little guide for you. It's not the full, the book is what has all the details, but just to give you a little broad view, there are courts of limited jurisdiction and courts of general jurisdictions. The court of limited jurisdiction will be the lower courts, court of general sessions, or the district courts, as some call them. They deal with issues where they can issue search and arrest warrants. They can set bonds for persons to be released from custody. They can hold preliminary hearings and on criminal charges, and they can they can have trials for misdemeanor charges, but they cannot deal with felonies. Any felony has to go to the courts of general jurisdiction. We'll get there in a minute. Another court of limited jurisdiction are the juvenile courts. Not all the districts will have juvenile courts. Davidson County has one, for example, because they are a big county. I'm not sure if, and sometimes they are individual and independent juvenile courts. Sometimes they are handled under the circuit courts. We know what they are. They deal with crimes committed by juveniles, minors or dependent neglected, or all of that stuff. And then municipal courts, which are the ones that deal with issues with, like, for example, people not putting the garbage out or not cutting their grass or not following that kind of municipal ordinances. The courts of general jurisdiction will be your circuit courts. Those have a broader jurisdiction, and they can try civil and criminal cases and appeal decisions from the courts of limited jurisdiction. So this is something that you need to study just to understand, not memorize, but understand, because you might have a case that might say, well, this case went to general sessions and it was granted, and then the person decided to submit an appeal, file an appeal. Where would that person file that appeal? So then you would have to just kind of think through it. Okay, if it was general sessions, then the next one will be the circuit court or the criminal court. You know what I mean? That's the kind of way how you have to study for the exam. They can try cases. They typically can deal with criminal cases as well, except for jurisdictions where there is a criminal court. Davidson County is one that has a circuit court and it has a criminal court, but the circuit court cannot handle criminal cases because there is a designated court for criminal courts. There is a criminal court specifically for that. Smaller districts, usually circuit courts handle the criminal courts as well. Chancery courts are courts of equity, they call it, and you can read more in detail in the book about this, and they can modify sometimes their ruling or the application of the law depending on what type of situation they're dealing with. They have a broader sort of a larger toolbox. They can change and modify things a little more, something that circuit courts or criminal courts cannot do. And those are typically civil cases, and they are, or like, you might deal there with name changes or, landlord tenant type of situations, or sometimes car accidents, trials, and things like that. Though those typically do go to circuit court. And then you have the criminal courts where the judges can also hear misdemeanor appeals from the lower court. Remember, from general session or juvenile or non-municipal usually. But they can do that, and they can handle all the criminal cases regardless of being misdemeanors or felonies. Probate courts are the ones that deal with wills and administration of states and conservatorship, which is when a person cannot take care of themselves. The court has to appoint a specific, person to either take care of their business, their financial affairs, or their medical affairs, or whatever is necessary. Again, I'm not going to stop a lot here. This is all theory, and I need you to make sure that you read this on the book, because these are very likely situations that will come up in a written exam. The Tennessee Supreme Court has 5 justices. They are located in Knoxville, Nashville, and Jackson. And they basically have the final word on issues that have to do with the law, the constitutionality of state statutes. They can set up state taxes, or the constitutionality of the state taxes, and they have the right to, and they can deal with issues of if a person has the right to hold or retain public office. Let's say that there is a complaint, or someone states that a public official that is already in charge, or that is trying to be elected, there could be some sort of filing that says that that person does not qualify for that because of X reasons, and the Tennessee Supreme Court is the one that will rule on that. Deals with constitutional law, and they might those questions can bypass the intermediate court, but they typically have to ask permission to be sent to the Supreme Court, and the Supreme Court does not always hear all the cases. So the process, from how does it happen? How do we go about taking a case from the crime, from when the crime occurs, to the process in criminal court, for example? So we talk about the offense, and we talked about the fact that it can be classified as a misdemeanor or a minor crime, something that is punishable, not a minor crime, but something that is punishable with up to 1 year in jail or alternative sentence, or a felony, which is a crime that is punishable with more than 1 year in jail. Not always the process will start with an arrest. Because, for example, if an police officer is called because there is a disturbance, and the officer gets there and there is a guy or a woman with a knife on their hand and somebody dead on the ground covered in blood, then yes, the person will be arrested right there probably. But it could also be that is a domestic disturbance where the officers get there and everything is over, and they have to start listening to both stories, or it might be a crime where there is a long process of investigation, and then there isn't immediately an arrest. There is an investigation before there is an arrest. In order for a police officer to issue or to request a warrant, an arrest warrant or a search warrant, there has to be something called reasonable suspicion. There has to be, the officer cannot stop you, for example. You cannot, just because you're driving down the road, an officer cannot just decide to stop you and say, oh, I want to see your license and registration. You must have done something, which is the reasonable suspicion. You might be swerving on the road. You might be driving weird, and he's thinking that maybe you are drunk, or it may be that they saw your cell phone light and they think that you're driving while texting or something. There has to be a reasonable suspicion. He can't just stop you. Again, the arrest can happen before or after being charged. In order for an arrest, so the first part, to be able to stop you or to even knock on your door or talk to you, whatever, for something like that, there has to be reasonable suspicion. For an arrest to occur, there has to be probable cause. A judge is who issues an arrest warrant, and for the judge to issue the arrest warrant, an officer has to go and swear the word. He has to do a sworn statement in front of a judge to request an arrest warrant or a search warrant, for them to be able to go and pick you up and arrest you or go to your house and search your house. So what is probable cause? Probable cause is a higher probability than not, meaning that is the standard of proof required to issue warrants. And any justices or the Supreme Court, Circuit or Criminal Court, General Sessions can issue warrants, and as well as the commissioners that are sometimes the sort of judges or that are running sort of the jail court at night and times like that, or after hours. We talked about the district attorney before. So the district attorney is the one that is going to bring up the formal accusations against an individual. The police officers are the ones that are on the streets, and they are investigators, and they find out certain things. They do all their investigation, and then they will come to the district attorney and say, we have these elements to be able to charge this person. So the district attorney will bring up those charges either directly to the grand jury. The grand jury is not the regular jury that you see in a jury trial. A grand jury is a group of people that is empaneled the same way as a regular jury, but they meet in private, and they only meet with the prosecution. They don't meet with the defense. The defense is not allowed in there. Only the victims or the witnesses of a crime will be there, and the police side, the prosecution side, is the one that is going to be there with them. They are the ones that review the case, and they review the evidence that the police or the prosecution is saying that they have against the person, and they determine if there is sufficient evidence or sufficient elements there to be able to actually bring charges against that person. So when they go directly to the grand jury, it's called a direct presentment. And those are generally crimes that they have such strong evidence that they go straight there, just to cut to the chase. In other words, they don't go through the typical process that we will see in court, which I'm going to go into now. Normally, in any other type of crime, in any other, if the direct presentment is an unusual thing that happens. But let's say, just know that is possible. Typically, what has to happen is that the district attorney issues a prosecutor's complaint, and then the defendant, the person being charged with the crime, has the right to a preliminary hearing. That means a hearing in front of a judge where the police or the prosecutor have to come, better say the prosecutor will bring witnesses, which often are the police officers, and they will show what is it that happened. They would testify. They will show any evidence that they have or part of the evidence. They don't have the obligation to show every piece of evidence there. So there may be a preliminary hearing. The person may also waive that right. This is a right, not an obligation. So the defendant, the person charged with the crime, can waive a preliminary hearing. There has to be probable cause. Remember, we talked before, in order for the preliminary hearing will determine if there is probable cause. And if the judge finds that there is probable cause, then they will again send it to the grand jury. That is the normal process that the crime goes to. The direct presentment is not it's an unusual it's a tool that the prosecution can use, but it's not the usual tool. Normally they go through the general sessions court, the courts of limited jurisdiction, and they have a preliminary hearing, or the person can waive their right to preliminary hearing, and that happens depending on the type of crime and whatever strategy the attorney is using. The grand jury, when the grand jury reviews the case, if they determine that there is probable cause, they will issue what is called a true bill. BILL. True bill is a document that says, yes, there is probable cause and these are the charges against this person. Now this person has to go through the trial courts, which is the courts of general jurisdiction, and they will determine one way or another if the person is guilty or not, or in other words, the person will be tried at the trial court level. As I mentioned before, there is a situation where the defendant may waive the right to a preliminary hearing. So let's say that there is a big period of time that happens between the preliminary hearing, the judge finding, let's say, okay, this happens one day, person is arrested, a couple of days, a week or two, whatever, very short after the arrest, there will be a preliminary hearing. Once the judge sends that to the grand jury or bounds it over, it's called, it was bound over to the grand jury, that process will take 4 to 6 months. 4 to 6 months from the moment they send this preliminary hearing or this case to the grand jury. There will be 4 to 6 months, if not longer, for the grand jury to determine if it's going to be going to the trial court through a true bill or a no true bill, and it will be dismissed. This means that some people that can't pay a bond can't get out of jail. So, and that happens a lot with individuals who are here illegally or undocumented, because the bonding companies will not bond them out because of the risk of them fleeing, and then they are out the money, the bonding company. So if the person does not, let's say, okay, it was a DUI, driving under the influence, or whatever, a theft, minor, whatever it is, they might decide that they don't want to wait for all that whole process. They know that the evidence is going to be clear, there is video, whatever happened, they just want to get it over with, and they don't want to wait for all that time. Then they might waive their right to a preliminary hearing and make an agreement directly with the prosecution to do an information plea petition, meaning they're going to plead guilty, but they won't have what is called as a formal indictment from the grand jury. The indictment is what the grand jury issues. At this point here, there is no indictment, and a person has the right to have a formal indictment by a grand jury, because that means that there is like an extra checks and balances, like a group of persons, people like us, anybody, somebody from the street, from a citizen, any other citizen, a peer, basically, reading over the facts and what happened and determining if there's going to be charges filed or not. So if the person says, no, I don't want to go through that process, I know that they're going to have, enough evidence or whatever, I just want to plea. So then the district attorney might make an offer. If normally a DUI first is 12 months in jail, or 24, so normally it's 12 months in jails or alternative sentence with a 2-day mandatory jail and a $350 fee and blah 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 blah. So the district attorney may say, let's say that it was a second DUI, the district attorney may say, okay, we'll let you plead to a DUI first, which is a smaller penalty. In other words, less time in jail, less money to pay fees and things like that. So that happens sometimes because the defendant waived their right to their preliminary hearing. If not, then remember, then on the other hand, if it is just a misdemeanor, if the offense is a misdemeanor, it might be just a citation or a summons, and or they can, in other words, the officer can issue just a citation, a summons, or can make an arrest. A citation is what we know as a traffic ticket. A summons is that the officer will actually go to the prosecutor and deal with them. Is kind of a little more complicated process where they will ask the prosecution to determine if charges should be brought up or if the case should be investigated or not, and then ultimately would be an arrest warrant. Like I said before, if the officer comes there and the issue was there and you find the guy in the middle of committing the crime, then the person will be arrested there. That's why a lot of times people don't understand what evidence actually means, because when somebody's arrested or when we deal with our clients, often they will say, well, what evidence do they have? What evidence do they have? They have the word of the officer. The testimony of a police officer or any witness is evidence. Evidence is not necessarily just video or photos or recordings or anything like that. Evidence is also the word of a witness or someone or the officer when they got there. In general sessions, again, you had a preliminary hearing. It went to the grand jury before, like I was saying before, and the jury sent the case to the criminal court. At the criminal court, the first thing is going to happen is an arraignment, or the formal reading of the charges of that person, meaning that person is going to receive a subpoena, a summons to appear in court if they are on bond, or they will be brought to court from the jail, and they will be told, yeah, the grand jury issued an indictment, and therefore now we're going to do the arraignment. It's the first appearance in front of a judge. At that appearance, that is a very short court proceeding for us. It is basically a very just simple and formal thing. Usually they will ask the person if they can hire their own attorney. If they can't afford their own attorney, then they'll have to just fill out an affidavit of indigency. Based on their income, the judge will determine if they can have an appointed attorney, an attorney assigned by the court and paid by the court to represent them, and that attorney can be a public defender or it can be a private attorney that was appointed to represent them. Discussions are after that, at that point, they will just read it. Usually they waive the right to the reading of the charges. So usually that proceeding goes something like this. The attorney will pick up the piece of paper and they will say, Your Honor, on behalf of Mr. So-and-so, we acknowledge receipt of indictment number such and such. We plead not guilty to all the charges included therein. We are aware of the future of the scheduling order, and I will keep my client informed. And Mr. So-and-so, for the record, what is your name, date of birth, and whatever, Social Security if you have it, and then that's pretty much it. So when they say because the reason they waive the right to the reading of the charges, because the charges are written on that indictment. So in some courts they would actually go over that and read. They will say, you've been accused of this and this and this and that, and that happens sometimes in general sessions. In criminal court, usually once the person is indicted, remember, in general sessions the person is not indicted yet, is only there for the preliminary hearing. The person is indicted once there is an indictment issued by the grand jury after the preliminary hearing or a direct presentment. So when that proceeding happens on the arraignment, basically the person is made aware that there are these official charges, and it also, the clock starts ticking. So they will actually, at this point, the defense attorney will file a request for discovery. The discovery is the package of evidence that the prosecution is intending to use against their client. So the each party, both, have to disclose everything they have, the prosecution to the defense and the defense to the prosecution. Typically, the prosecution is the one that has the evidence, so they have to give the defense everything they have. Not everything. There are some things that are, the law is very complicated. There are certain things that are mandatory to be discovered or given in discovery. And there are things that they don't have the obligation, that they can litigate, that the defense might find out that they have something, and let's say they might not give them body cams, or they might not give them the recording of an interview, or it may be a minor involved and they don't want to give them. There are many things that happen, but in general, they have a discovery package, which would be the police complaint, what they're saying that happened, and what are they accusing their client of. And with that, it actually is the first time that the defense will see actually what they have against their client. Remember that we had some people waived their right to a preliminary hearing. Even if they had a preliminary hearing, the police, when they testify, they don't tell them absolutely everything they have. There are certain things that can be kept private until there is an arraignment. At this point, the defense will file the request for discovery. Now it makes it official, it's on the record, and the district attorney or the prosecution has to come back and give that material to them, to the defense, within a certain period of time, which is typically 30 days or something like that. If they don't do that, now a series of litigation can start occurring again. The defense might be filing, compelling, a motion to compel and things like that. So there are many things that happen there. But let's say that everything goes as planned. There is an arraignment. There is a filing for discovery. Within 30 days, the prosecution has to give the defense all the evidence, and now the defense will be able to meet with their client and discuss the case and go over that evidence. Every time there's going to be, it's not like, okay, they don't come back. Some courts may only give you then a court date for a year from now for settlement, for a trial date. Most of the time they will give you 3 or 4 discussion dates, or they call them pre-trial conference dates, where it'll happen every month or every 45 days or something like that, where to make sure that the attorney has the opportunity to talk to their client. It doesn't happen in all the districts. It sometimes happens in certain places. But that's what a discussion is. It's a time where the defendant is going to come to court. The defense attorney will be there. They will be talking to the prosecution to try to resolve the case. They're going to go over the evidence again. So usually those, you're just interpreting part of it, or it might be a longer encounter where the defense attorney really wants to have a conversation with them and try to settle the case, or it might be that you go to jail with the defense attorney to talk about the case, to explain everything and to go over the evidence and things like that. The AOC will not keep in mind this. Often some people will say the defendant has the right to that discovery package. You are not going to don't get into translating documents without getting prior approval, because the AOC will not always just pay straightforward. There are many things you have to keep in mind before you do that. Limit yourself to interpreting. If there is translating to be done, usually the AOC will say the attorney can go over that discovery package with an interpreter, but they might not pay for an actual translation for the person to be able to read it. It depends. So just keep in mind that. The discovery, there may be motions, like I said before, motions to compel, motions to obligate the one party or the other to disclose things that they're not disclosing, or motions to bring a certain witness, or motions to suppress certain evidence because the procedure for the arrest was not done properly, or things like that. There are many times that there can be motions. Those are hearings in front of a judge. Other than that, you don't see, the defendant doesn't see the judge until there is a resolution. That's another misconception, that often people from other countries want to speak with the judge. The judge does not speak with you. The judge the judge has assigned an attorney to you, and the judge does not want to hear the case because the judge is only a referee. He is an impartial party. He's there to make sure that the law is being followed and being, that the rights of that person are being protected in a way. So there are only two ways of resolve a criminal case in the criminal system, and that is either the person goes to trial in front of a jury or a judge, or there is a plea deal. A plea deal means that the defense and the prosecution have come to an agreement where, let's say that the person was charged with armed robbery, and that carries a sentence. The book says that armed robbery is and I am just guessing here, I don't know it, but let's say that the annotated code of Tennessee says that armed robbery is a B felony and it carries 15 to 25 years. The reason why they say 15 to 25 is because there are ranges of offenders, people who have not had any crime, any offense before, any sentencing, any charges before, any criminal history before. They are first time offenders and they're considered range 1. If they are they have already been charged and have had a sentence of any sort, they might be range 2. It depends. A complicated thing again, but the bottom line is that, let's say that a armed robbery is a B felony and the minimum is 15 and the maximum is 25 years. Then they might decide, the district attorney can't just decide to just give you 10 instead of 15, because the range of punishment for that felony charge is 15 to 25. In order for the district attorney to lower that below 15, he has to lower the charge. He has to amend the charge. So let's say that the original charge with what they accused the person was, they charged the person was armed robbery. They might bring that down to theft. And maybe that now is a C felony, which has a range of sentence of 8 to 15. So now instead of giving him 15, which was the minimum for the armed robbery, he can give him 8, which is the minimum on that lower charge. But he has to amend the charge. A person cannot plead. There are circumstances where they can plead to a higher range. Complicated. I'm not going to get you confused with that. That's a later conversation. But that is how a plea deal works. So the reason for that to occur is because the district attorney may not, the prosecution may not want to go to trial for many reasons. It may be because the charge is a minor, the smaller thing. It may be because they have too many trials. It may be because they can't find the witness. And if there is no witness, there is no case. So all of those things are taken into consideration when the district attorney is going to take a case to trial. And usually, most of the time, they just try to resolve it and there is a plea deal at some point. If there is a trial, the trial can be, so there are only two ways to resolve it. That is very hard for people to understand here sometimes, people from other countries. There is no other way. Usually, for example, with serious cases like rape or rape of a child, you have two options. Either you plead guilty. When we talk about a plea deal, we are talking about the person having to plead guilty. Go in front of the judge and say, yes, I'm guilty. Otherwise, you can't accept the plea deal. So either you plead guilty or you go to trial. And the risk of going to trial is sometimes very scary. So people end up pleading guilty even if they are innocent. That's a complicated concept as well, something that we hopefully can talk in class. But if they decide to go to trial, they can choose to ask for a jury trial or a non-jury trial. A non-jury trial is simply in front of a judge. The judge will listen to all the facts and determine if the prosecution has proven beyond reasonable doubt that the person is guilty or not. The jury trial means that we are now going to in all of people, which are people from, citizens, peers, our peers, people without any specific training or any specific um, education or anything. It might be anybody. It might be someone completely uneducated. Many of us have gotten summons to appear in court to serve as a juror. So it is a mandatory thing. It's a right, but it's basically, if you don't show up, they're going to send you another summons that you have to appear. Otherwise, you will be in contempt of the court if you don't appear for jury duty. So what happens in that circumstances is, like, let's say there is a jury trial, they will send 50 or 100 summons to 50 or 100 people from the community. They all have to be citizens, U.S. citizens. They cannot be just resident. It has to be citizens, and they will appear the day that they tell them, and they will get a little orientation, and then they're going to send them to different courtrooms. They might send, let's say, 30 people or 50 people to one courtroom. They were going to sit all in the gallery, and then the defense attorney and the district attorney will ask questions. Better say, one step back. They will actually select 12 people out of those 50 or 40 or whatever. They'll put them on the jury box, and the defense attorney and the district attorney will ask questions to determine if they like that person, if they think that person can be objective and be, is able to be unbiased and listen to all the facts. So that is a little. Let me just finish on this part. So the discovery, like I said, was the part, all the evidence of the case. That sometimes there are some translations there. Be careful if they ask you for that, because those are like this thick, and the AOC will not always pay for that. Video or audio proof. Remember, you should never do this live in court. We swear an oath to interpret to the best of our ability. Rule of evidence says that anything that is in any language other than English should be transcribed, and that transcription becomes the evidence and not the actual audio or video, because nobody can understand if it is in another language. So that is a very big issue. Unfortunately, in Tennessee, it's not regulated, it's not mandated at the AOC level, but you should know that as a court interpreter, you should not do those live in court. They are supposed to transcribe and translate that, and that takes a very long time. There may be letters. Sometimes you go there and they might ask you to site translate something, or they might ask you to translate that for officially to put it on the record. And, those are easier to get paid for. There's usually not a problem there. So let's jump to the Court of Appeals. In the Court of Appeals, there are courts of criminal appeals, and those usually we're not there. People don't go there. Those are handled with briefs or the record of the court and arguments, and the Court of Appeals will issue an opinion, but there are no people there. The defendant doesn't go there, the interpreter doesn't go there. So this is just basically for you to know the process. The an attorney has to ask permission to, let's say that the case was denied they are not successful in the Court of Appeals. That means, like, the reason for going to the Court of Appeals is because there was an error in the lower court, on the criminal court, or the court of general jurisdiction. So it's not like you can just go and appeal and say, I didn't like it, that they found me guilty. There has to be specific reasons, specific things that the attorneys will write down in a brief. And then, and for example, one of the things is, you hear in the trials or in any kind of hearings, objection. Every time somebody says objection, the judge has to give a decision about that. And if that decision was wrong, that is one of the things that the attorney will argue, that decision, that ruling the judge did on that particular objection was wrong. Therefore, we want you to revert this, send this case back. Winning an appeal doesn't mean that now your client is out loose. It only means that if there was a jury trial or a bench trial and the person was found guilty, but the Court of Appeals determines that there was error in the process, either the judge err on a certain particular thing or the attorney or whatever it was the issue, the Court of Appeals will remand. They will send that case back to the court where it was tried. So now the case has to start again. And the reason for that, in other words, the reason, the benefit of that of appealing, you might say, well, why are you appealing then? Well, because sometimes the second time the district attorney may decide not to prosecute. They may decide that, okay, you've been in jail for 10 years already, or 5 years or whatever, we're just gonna call it time served, and then you plead guilty and you get out. The result can be completely different depending on what the error was and what the evidence is. The district attorney may decide not to prosecute. So in order to appeal a decision of the Court of Appeals to the Supreme Court now of Tennessee, not the U.S. Supreme Court, to the Tennessee Supreme Court, the attorney has to ask permission to the. So finally, or actually firstly, I should probably start with this. The reason all of this happened, and one of the things that we always interpret, and you will interpret this until you're blue in the face, and you would probably end up memorizing it like most of us do. The U.S. Constitution provides that in all criminal prosecutions, every person that is accused of a crime shall enjoy the right to a speedy and public trial by an impartial jury. That's why the jury is people from the community. They're your peers. They're not, from a political party. They're not from the prosecutors. They're general people, and both of them have, defense and prosecution have the right to pick and choose through those people. And hopefully we had a chance to talk about this in detail in class as well, in a little more detail. But so the right to a speedy trial doesn't mean that the trial has to be done in tomorrow or in a week. It means that it has to be set as soon as possible. And that's because there are many processes that have to happen before you can go to a trial. So the right to a speedy trial and public trial by an impartial jury, the right to see, hear, and cross-examine all witnesses against that person. In other words, they have, every time that there is a criminal prosecution, the people, if you can't say that somebody said something about the defendant or saw something unless that person is there, because the defendant through his attorney has the right to ask questions to that witness. The right to use the power and process of the court to compel the production of any evidence, including the attendance of witnesses in his or her favor, meaning sometimes there may be some witness that may exonerate the person. So let's say that person says, I'm not going to court there, which happens quite often. I'm not going to go there. I'm not going to, I'm afraid of the killers or the whatever, whatever it is. The court can actually issue a court order and force that person to come to court, even if they have to actually go and arrest them and make them spend the night in jail, in order for that person to be there for a trial or a hearing or whatever it is. I've seen it happen. The right to have the assistance of counsel, of an attorney, in all stages of the proceedings. That means, and if you cannot afford one, the court will assign one for you free of charge. The right to remain silent and not testify, and that silence cannot be used against him or her. And that means that a defendant doesn't have any obligation to testify. If he wants to testify, he can. But there is no rule or anything that says that the person has to put any kind of evidence to defend him or herself. The prosecution has the obligation to prove beyond reasonable doubt. That is the bar, basically. They have to prove beyond reasonable doubt that the person committed the crime, and they have to, for that, they have to show the elements of the crime. For example, and I'm just gonna guess here a little bit, if it's a first degree murder, in order for it to, this isn't guess, in order for a crime to be first degree murder, the district attorney has to prove that the person did that intentionally, knowingly, and with premeditation, that he or she knew that he was going to do that and went with the intention of killing someone. Now, you might say, oh yeah, like, how are you going to prove only like if the person was writing notes or preparing his weapons or whatever it is? No, it can be actually, some premeditation can be proven in the actual moment of committing the crime. Typically, a person that kills somebody else by choking, or any kind of family cases, domestic cases, if there is choking, that automatically implies premeditation, because how much out of your mind do you have to be to actually grab a person? Do you know how long it takes for you to actually choke someone to death? So in order for you to continue squeezing, you are aware of what you're doing. Therefore, there is premeditation. Even though you didn't come here with the idea of killing someone, you are choking that person with the idea of killing that person. So that indicates premeditation. So those things that district attorney, the prosecution, has to prove beyond reasonable doubt. And that is for the jury to decide. That is not something that is black and white. That depends on what the jury thinks about the strengths of the case. We're going to finish here and move on to a third video that will come up. And I hope this serves you a little bit as a guide for studying. But again, go back to your book. That's where all the information is in more depth. Thank you.